Thank you, Mr. Speaker. It's a real honor to be able to speak to the second reading of C-54, the Not Criminally Responsible Reform Act. As we know, the Government of Canada is committed to protecting victims of crime and to making our streets and our communities safer for all Canadians. To this end, last February 8th of this year, our government introduced the Not Criminally Responsible Reform Act. The Act would ensure that public safety comes first in the decision-making process with respect to accused persons found not criminally responsible on account of a mental disorder, and to enhance the safety of victims and promote greater victim involvement in the Criminal Code mental disorder regime. Mr. Speaker, when this bill was first introduced last February, I'm sure that many of us, if not all of our offices, received support from across this great country. We each receive a lot of input through emails, phone calls, letters, and when we're at community meetings, and time again, when this was first introduced in February, there was a lot of positive response to this. Canadians want this. Victims need this. Mr. Speaker, the Criminal Code mental disorder regime applies to a very small percentage of accused persons. Under Canadian criminal law, if an accused person cannot understand what the nature of the trial is or its consequences, and cannot communicate with their lawyer on account of a mental disorder, the court will find that the person is unfit to stand trial. Once an accused becomes fit to stand trial, they will then be tried for the offense for which they were initially charged. If a person is found to have committed the act that constitutes an offense, but lacked the capacity to appreciate what they did, or know that it was wrong due to a mental disorder at the time, the court makes a special verdict of not criminally responsible on account of a mental disorder, also known as NCR. They are neither convicted or acquitted. A person found either unfit to stand trial or NCR, Mr. Speaker, the board then decides on a course of action. Under the current law, the review board can make one of three possible decisions. If the person does not pose a significant threat to public safety, an absolute discharge could be made, or a conditional discharge or detention in custody in a hospital. Now, this bill, C-54, proposes to amend the mental disorder regime, which deals with accused persons who are found to be unfit to stand trial or have an NCR. The legislative amendments to the mental disorder regime of the Criminal Code proposed in the Not Criminally Responsible Reform Act would explicitly make public safety the paramount consideration in the court and the review board decision-making process related to accused persons found to be NCR or unfit to stand trial. The legislation would amend the Criminal Code to create a process for the designation of NCR accused persons as high risk where the accused person has been found NCR of a serious personal injury offense, and there is a substantial likelihood for further violence that would endanger the public, or in cases in which the acts were of such a brutal nature as to indicate a risk of grave harm to the public. Now, there's been a lot of comment that has been made in this House over the last number of hours, and hopefully that clarifies this. This is to be considered in the most dangerous and extreme cases. Those designated as high-risk NCR accused persons would not be granted a condition or absolute discharge, and the designation could only be revoked by the court following a recommendation of the review board. This designation would apply only to those found NCR and not to persons found unfit to stand the trial. The proposed legislation outlines that high-risk NCR accused persons would not be allowed to go into the community unescorted. The public supports that. And escorted passes would only be allowed in narrow circumstances and subject to significant conditions to protect the public safety. Canadians support that. Also, the review board may decide to extend the review period for up to 3 years for those designated high risk instead of annually. Canadians support that. The high-risk NCR designation would not affect access to treatment by the accused. Canadians support that. In addition, the proposed reforms would codify the meaning of significant threat for safety, significant threat to the safety of the public, which is the current test used to determine whether a review board can maintain jurisdiction and continue to supervise a mentally disordered accused. It would clarify that the risk to the public safety must be criminal in nature, but not necessarily violent in form for restrictions to be imposed on the accused. The legislation would enhance the safety of victims and provide them with opportunities for greater involvement in the criminal code mental disorder regime by ensuring that they're notified upon request when the accused is discharged, allowing non-communication orders between the accused and the victim, and ensuring that the safety of victims be considered when decisions are being made about an accused person. Mr. Speaker, this is what I have heard also from Canadians, the importance of the consideration of the families of the victims. Often we've heard that the consideration of these families that are dealing with a loss and a traumatic situation in their lives, their consideration and their involvement need to be considered, and in way too often, Mr. Speaker, that has not happened. Provisions of the proposed legislation would also help to ensure consistent interpretation and of application of the law across our great country. These proposed reforms would not change the existing criminal code eligibility criteria for the exemption from criminal responsibility on account of mental disorder. Since the introduction of the Federal Victim Strategy in 2008, our government has responded to the needs of victims of crime in an effort to give them a more effective voice in the criminal justice system. And Canadians are very happy with that, what has been accomplished. Funding has been provided to projects and activities that enhance victim assistance programs across Canada, that promote access to justice and participation in the justice system and the development of law, policies, and programs. To promote the implementation of principles, guidelines, and laws designed to address the needs of victims of crime and articulate their role in the criminal justice system. Contribute to increased knowledge and awareness of the impact of victimization, the needs of victims of crime, available services, assistance in programs and legislation, and also to promote, encourage, and enhance governmental and non-governmental organizations' involvement in the identification of victims' needs and gaps in service, and in the development and delivery of programs, services, and assistance to victims, including capacity building in the non-governmental organizations. Mr. Speaker, the legislation in review, and how much time do I have, Mr. Speaker? 1 minute. So the legislation will enhance victims' rights. The legislation will enhance the safety of victims by ensuring that they are specifically considered when decisions are being made about accused persons found NCR. We will put the public safety first. The legislation will explicitly set out that public safety is the paramount consideration in the decision-making process, and the legislation would create a new designation to protect the public from high-risk NCR accused. Mr. Speaker, Canadians want this, Canadians need this, and I encourage all members to support this. Thank you.